Hello, I'm very fortunate to be joined again by Professor Vernon Bogdanor to talk generally about constitutional matters that we think might be affecting us in the forthcoming year, 2021. We've had probably quite a few recent years where there's been a lot of constitutional turmoil, a lot of it connected to Brexit, but also linking up to various other matters. We've now left the European Union about a year ago, and we've also got a partial deal to deal with post-Brexit arrangements between the UK and the EU. But does that mean everything's going to go back to being gentle and calm on the constitutional front in 2021? And in particular, Vernon, do you think the territorial constitution of the UK is going to be settled, or do you think Brexit's actually going to have some kind of after effects in that area?
Well, these, of course, are very large questions. And Brexit itself was a vast constitutional issue because one of the motivations behind it was to restore sovereignty, to restore control, the control of Parliament. But now that we have done that, new constitutional issues arise because we return, as you say, to what we were before we joined Europe in 1973. And shortly after we joined, Lord Hailsham, who had been and was to become again Conservative Lord Chancellor, said that we lived under a system of elective dictatorship, another way of describing parliamentary sovereignty, if you like. Now, the question is whether we will again return to that system. Now, I think we probably won't, because too much has happened since those years. Because in 1973, after all, we didn't have devolution to Scotland, Wales, and Northern Ireland. We didn't have directly elected mayors. We didn't have the Human Rights Act. Indeed, we didn't have the institution of the referendum. That was an innovation in 1975. So it's a different constitution from what it was before we joined. And although in form, the sovereignty of Parliament remains intact, in practice, it doesn't really, because although Westminster can intervene in the case of Scotland, Wales and Northern Ireland, and indeed it has done with the Internal Market Bill, that intervention is very rare and it causes a lot of political trouble. And although Parliament can ignore a decision by the judges that the Human Rights Act is breached, it has hardly done so. The only occasion is on the question of the ban on prisoners' voting rights. And there it's fair to say the government some years ago promised it would put that right. It hasn't yet done so. On every other occasion, when the judges have made a judgment on human rights, Parliament has adopted the change that the judges have suggested. And then again, the referendum formally doesn't conflict with parliamentary sovereignty. In practice, it does. And perhaps it's worth pointing out the huge effect of the Brexit referendum. For the first time in British history, Parliament was required to do, not legally required, but politically required, to do something, namely to take Britain out of the European Union, which majority in Parliament, both in the Commons and in the Lords, did not want to do. The majority of MPs were against Brexit. The majority of Conservative MPs at the time were against Brexit. The majority in the cabinet were against Brexit. And of course, a large majority of peers were against Brexit. Nevertheless, they felt constrained to do something which, as it were, on a free vote, they wouldn't have done. So that's first in our constitutional history. And one of our colleagues in the Law Department at King's, Takis Tridimus, he said, for this reason, the Brexit referendum is the most significant constitutional event in Britain since the restoration of the monarchy in 1660. It was a very important occasion. Now you ask about the territorial constitution, and of course that has been put back in the melting pot, because one thing that Europe did was to preserve an internal market within the United Kingdom as part of the whole EU internal market. Now, there's some danger that that will be undermined by Brexit, because it's possible that Scotland, Wales and Northern Ireland would adopt policies that would undermine that internal market. And Brexit itself has caused a barrier between Northern Ireland and the rest of Britain, because Northern Ireland remains within the EU regulatory area, and therefore, if the rest of the country decides to change its regulations, there's a barrier in the Irish Sea between Great Britain and Northern Ireland. Now, Northern Ireland formally leaves the customs union with the rest of the country. But if you look carefully at the small print, as it were, of the Northern Ireland Protocol, Northern Ireland remains committed to EU customs rules. So again, there's a customs barrier in the Irish Sea as well. So Northern Ireland is being pushed in a way towards a republic, which of course remains in the European Union, and away from the rest of the country. And of course, in the case of Northern Ireland and Scotland, they both voted against Brexit. So the majority in those parts of the United Kingdom can say, well, look, we're only leaving the EU because of English and Welsh votes. We didn't want to leave the EU, and in particular, the Scottish nationalists say we'd be much better off remaining in the EU. So that's given a fillip to Scottish nationalism. They can say, well, Scotland never gets listened to, and we are being required to adopt a policy we don't favour. And Northern Ireland, in a way, the situation is even easier, because whereas Scotland would have to apply to join the European Union after independence, and I'm fairly sure it would secure entry, but though it's not clear on what terms, Northern Ireland would not have to apply because it would become part of the Republic of Ireland, which of course is already a member. It would be like East Germany joining with West Germany. It would just be an additional territory for an already existing member. So that makes it much easier for Northern Ireland in a way. So it's fair to say that Brexit has put the territorial constitution under some strain. And the Scottish nationalists in particular say, well, if people had known in 2014 that Scotland wouldn't be in the EU, they might have voted differently, because they were told that remaining in the United Kingdom was one way of being sure that Scotland would remain in the EU. Now, this isn't happening. So they say, the Scottish nationalists say, this is a case for a second independence referendum, which of course the British government at the moment is strongly resisting.
And what is the path to Scottish independence? Because legally, that's quite a complex matter. As you say, if the UK government doesn't want there to be a referendum, but if there is sufficient sustained support demonstrated among the Scottish public, how can they get there, if they can get there at all? And then are we likely to see the UK Supreme Court becoming involved in all of this, in your view?
Well, as you say, the power to hold a referendum is a reserved power in the hands of Westminster. The Scots could, I suppose, arguably hold a consultative referendum, and that might well go to the Supreme Court, whether that was an appropriate spending of public money, whether it's within the vires of the Scottish Parliament to spend money on that. The great danger with that is that the Unionists might well simply decide to boycott the referendum, and so the result would not appear sensible in any way, and there's no guarantee it would be properly carried out. I don't myself believe the SNP would follow the Catalonians in holding such a referendum. They're a strictly constitutional party, always have been, I think, always will be. I don't myself agree with their position, but they're perfectly entitled to argue it, and they are a constitutional party. So I think the answer to your question of the path, it depends on political will. Can Westminster continually ignore, for how long could it ignore, repeated majorities of the SNP on an independent platform in Scotland? And that's a question, of course, none of us can answer. It's not a legal or constitutional question, it's a question about political will. For the moment, the British government's position is, even if the SNP win the Holyrood election in May, there should not be another referendum. And they quote what Alex Salmond said in 2014, it was a once in a generation opportunity. Now, the SNP, as I've said, They say, well, you've got to read small print, though it's invisible small print, that if Scotland was pushed out of the EU against its will, that would alter the situation. But these are political arguments.
And while we think a bit about the role the courts might play, part of the agenda of the present government, aside from Brexit, was to review the role that the courts are playing. They took the view expressed in a manifesto that in some senses the judiciary has overreached itself, extended into political matters which it shouldn't be meddling with, that kind of argument. 2 reviews have been set up, one on administrative law, another looking at updating, I think was the word, the Human Rights Act. Do you think that's going to go anywhere? What do you see as being the political and legal consequences of those 2 processes?
Well, of course, the role of the courts has increased enormously during our lifetime. If you were teaching the British government in the 1950s, for example, I think you wouldn't need to mention the courts at all. There's no chapter on the courts, for example, in Bagehot's book on the English Constitution, written in the 19th century. And I think a number of textbooks on British government from that time would hardly mention the courts. Now you'd have to mention the courts, and I think anyone studying British government has to know a bit about the law. Now, there have been a number of reasons for this. The main one, perhaps, is the constitutional reforms we've had, which all give the courts a greater role. For example, devolution. It's up to the courts to decide whether the devolved bodies in Scotland, Wales and Northern Ireland are acting within their powers. On the Human Rights Act, this gives the court the power to issue a declaration of incompatibility on human rights. Those matters used to go to Strasbourg, the European Court of Human Rights. They're now decided by our domestic courts. And then most important of all, and perhaps insufficiently noticed, that Europe itself gave a huge role for the courts because the British courts had a role in deciding whether Westminster legislation was compatible with European law. So when we joined Europe, there wasn't only a shift from Westminster to Brussels, there was a shift within Britain from the executive and parliament to the courts. And that became most obvious, so it was implicit in my opinion in the legislation, the European Communities Act, most obvious in the famous Factortame case of 1991, when the courts did something that Dicey, followed by Lord Hailsham and Sir Geoffrey Howe and lots of others, thought was impossible. They disapplied an act of Parliament, or part of an act of Parliament, the Merchant Shipping Act. And that is a very strange thing to do if you think Parliament is sovereign. They said this act is not legal because it conflicts, it's not lawful, it conflicts with European Union law. Now, all this was taken a step further, a big step further, in my opinion, when we had the European Charter of Human Rights under the Lisbon Treaty of 2007, came into force in 2009. Now, British governments, both Labour and Conservative, said, doesn't affect us, we've got an opt-out from it, and in any case it won't make any difference. Now, both of those propositions rapidly proved untrue, and you couldn't imagine a European Union in which there were rights in some countries but not in others, and major rights. Now, the European Charter of Human Rights, which perhaps hasn't been studied enough, is much wider than the European Convention. It contains 54 articles, and it contains a lot of rights which perhaps were not thought about much in the early 1950s. For example, right to environmental protection, right to academic freedom, very important for us, a right to non-discrimination on grounds of gender, religion, region, sexual orientation, and so on. Now, that wasn't much thought of in the early 50s. After all, homosexuality was illegal in many European countries at that time. So rights developed through time, and the rights in the European Convention, perhaps appropriate for the early 1950s, not so appropriate 60, 70 years later. And in a case that came before the Supreme Court in 2017, the Benk-Harbouch case, Ms. Benk-Harbouch brought a case against the Sudanese embassy who weren't paying her the minimum wage and not treating her in other ways she thought were reasonable. And the embassy pleaded diplomatic immunity under a British Act of Parliament. And the court said you can't do that, that everybody's entitled under the Charter to a remedy. And this goes against rights, that we can do more than issue a declaration of incompatibility which has no legal force. We must say that this Act of Parliament giving immunity, diplomatic immunity, parts of it must be disapplied. We're not going to apply it. And so Ms. Ben-Carbush won her case. That was, in my view, as much of a landmark case as Factortame. Now, you perhaps won't be surprised to hear that leaving the European Union, although almost all European Union legislation is being incorporated into our own system so that we can decide, or Parliament can decide, which it wants to keep, which it wants to modify, which it wants to repeal. The European Charter is not being incorporated. So this brings us back to an unprotected constitution, Hailsham's elective dictatorship again, if you like. Now, this present government wants to go even further and possibly to restrict the Human Rights Act and rights to judicial review. And that seems to me rather odd, because judicial review says ministers should act within their powers, the powers of Parliament. Are the courts meant to say, well, this doesn't fall within the powers of Parliament, but never mind? It's a bit odd. And the Human Rights Act is a very minimum standard that every country in the Council of Europe, which I think includes all European countries except Russia and Belarus, they all subscribe to it. And I think it'd be a pity if we weaken the already perhaps fairly limited powers which judges have. It's fair to say that judges in Britain, now we've left the European Union, don't have the power to strike down legislation against human rights because we're not incorporating the Charter. Whereas, of course, judges in every other European Union country do have that power. They retain that power, including Ireland. And of course, America and Canada and most other democracies have that power. We have to ask ourselves the question, are our MPs so much more sensitive to the protection of human rights than legislators in other countries that they should be entrusted with this vital function? I think the question answers itself. It's a question, incidentally, that Lord Sumption doesn't answer in his Reith lectures, which argue against an activist judiciary. And I think it should be asked at least. And it's worth remembering two things. Firstly, that a lot of the rights which judges try to protect are the rights of very unpopular, sometimes not necessarily attractive minorities. I mean, prisoners, for example, suspected terrorists, asylum seekers, all sorts of people, very small, unpopular minorities who don't get into the electoral process. They're just as entitled to protection as you and I. Rights aren't necessarily for nice people. But of course, you and I could at any time be charged, arrested while innocent, and so on. We might need the protection of the Human Rights Act at any time. You cannot predict. And the second point worth mentioning is really an aphorism by the late Lord Bingham, thought by many to be the greatest judge in Britain since the war. It was a time when he made a decision, I think, against detention in Belmarsh at the time of the Iraq War, detention without trial of terrorists. And the government, of course, were furious. Lord Bingham said, there are countries where the judges always agree with the government, but they're not countries in which any of us would actually like to live. I suspect if you lived in Iran or Russia or China, the judges there always agree with the government. There are never clashes between the government and the judiciary. And this illustrates the point I'm trying to make, that the clash between the government and the judiciary is expected. It's a part of democratic government. So the judges, far from being enemies of the people, are actually an important part of any democratic state, any modern democratic state. Behind all that, I think, lies the proposition, which again comes back to the elective dictatorship point. The fact that a majority has won a free election doesn't mean it's entitled to do whatever it likes. It must be restricted. In the past, it was restricted by so-called constitutional conventions. that's probably not enough now. People demand something more. They're less deferential than they were, more assertive, determined to obtain their rights. And for that purpose, the judges, the judiciary are essential, in my opinion.
And on the point of a majority in the House of Commons has rarely arisen from actually achieving a majority of the votes cast in the election under our electoral system. So you could argue that that problem is magnified, that it's actually a plurality or a minority that can win a majority and then do those things you're talking about.
Ah, yes, well, this raises another large question, of course, the electoral system. And here too, of course, there have been tremendous changes because before the 1970s, proportional representation was not used anywhere in Britain, but then it was introduced in Northern Ireland in the proposals for a new devolved body. It was argued the conditions in Northern Ireland were special. But then it was introduced also for the other devolved bodies in Scotland and Wales, also for the London Assembly.
Yeah.
And in Scotland, they decided to have proportional representation also for local government. So the kind of creeping tide, as it were, of proportional representation. We don't have it for Parliament or local government in England. And they may be coming to look like exceptions. Now, of course, proportional representation had a huge effect because it helped parties like Nigel Farage's UKIP. Yeah. And he said without proportional representation, we wouldn't have got anywhere. It may have helped the SNP as well. In Scotland, it helped the Conservatives, who are a minority party. Now, it may also have given people the habit of voting for minority parties, getting used to that, and thereby increasing the fragmentation in the House of Commons. So it's a very large question. Now, of course, it's on the back burner for the moment because we had a referendum on the alternative vote in 2011, which isn't a system of proportional representation, but perhaps many thought it was, I don't know. But anyway, it was defeated by 4-1, and that means there won't be another referendum perhaps for some time. But of course, it's an issue, as you say, that governments can win large majorities on a minority of the vote. Perhaps worth pointing out the landslides won by Margaret Thatcher and Tony Blair both won on about 42% of the vote, and it means nearly 3/5 of the voters voted against them. So we should be careful when analysing the causes for election victories.
If the present government were going to try and proceed with restrictions on the ability of the judiciary to review executive exercise of its powers, one place where they might meet with resistance is the House of Lords. Now, the present government or people within it seem to have hinted at times they might have nasty plans for the Lords if the Lords was to get in their way. What do you think the actual prospects for that are in the near to medium term?
Well, I think Lords reform is a snake pit, frankly, and every government tried to get involved with that. The Wilson government in the late 60s, the Cameron government between 2010 and 15 has come a cropper, because what they want is to try and rationalise the Lords, because its composition is in a way irrational, but without increasing its powers. And I just don't think that's possible, because the more you rationalise it, the more it will say, well, as we're more legitimate now, we can afford to exercise some of the powers that previously they haven't been willing to exercise. For example, the old hereditary house was very careful indeed about using any powers against the government. It said we have no legitimacy in the modern world. The current house, which is primarily appointed, and appointed because of their expertise, said, well, we wouldn't have been appointed if people didn't think we were more legitimate than the old house, and therefore we should be entitled to use our powers. Even so, the House is very careful, and what the Lords can do, and does well, is to make the government think again on some issues, but they can't stop a determined government in its tracks, and nor should they. So I don't think they can be much of a barrier to constitutional reform or any other changes affecting perhaps the judiciary, but it's very difficult to hamstring the judiciary, and they could simply ignore any restrictions. They did, for example, in the famous Annis Minnick case in the late 60s, and an administrative law case where it said that the decision of a minister cannot be reviewed by the courts. The court said, we're not accepting that. We must be able to review the lawfulness of ministers' decisions. And there was another issue on which the same question could have arisen with an act passed by Tony Blair on asylum. The first draft of that gave asylum seekers whose claim had been rejected no right of appeal from the tribunal which rejected their claim. Now, if you can't get to the courts, the Human Rights Act is of no use. Now, that particular clause was rejected. I played some role in this because I wrote an article in the Times saying how monstrous this was. In fact, this came to the attention of the Lord Chief Justice, who was furious with the Home Secretary, and it was altered. But can you deny people access to the courts? Suppose you pass an act of parliament to that effect with the courts taking notice of it. And some judges have said obiter that parliamentary sovereignty is not unlimited. And if you try to pass legislation denying basic and fundamental rights, we would disapply it, we would ignore it. So it may not be as easy to limit the role of the courts as some in government tend to think.
Okay, now, while we're talking about things that have been tried before, like House of Lords reform, another thing that's been tried before, which the present government look like they're about to embark upon again, is civil service reform. Now, one of the people who was perhaps keenest on changes to the civil service, Dominic Cummings, has now exited the government, but there does seem to still be some kind of impetus behind this programme within the UK government. Do you think that what the present government is saying about the civil service and its faults is adding much to what's been said, at least as far back as the time as the Fulton reports in 1968? And do you think you're actually likely to get anywhere with this?
Well, I think that Dominic Cummings' views were not always, to be frank, totally coherent. I read his blog on the civil service. It's difficult to make sense of it. One point he did stress was that the days of a non-partisan, non-political, neutral civil service have gone. And I hope that's not true, because we can all be good Conservatives, Liberal Democrats or Labour, whatever it is, and we can all be good partisans. What's more difficult is to point out the snags in government proposals. And if you don't do that, you cost the country a lot of public money. Poll tax perhaps being one example. I think HS2 is another. That's perhaps more controversial. But it's very important that civil servants exercise that function and curb ministers' enthusiasms when they're not well founded on evidence. And I think our civil service does that very well. Now, the question of reform was begun, as you say, by Fulton, which I think was probably the worst Royal Commission report of the 20th century. There was some competition for that title, but the mistake Fulton made, I think, which has been made by many others since, including on the Next Steps programme and both governments, is that the civil service should adopt the customs and habits of private business. And I think that shows a fundamental misunderstanding of the way it operates, because the basic principle behind the civil service is that it lives in a system of ministerial responsibility to Parliament. There's no comparison with business. For example, the chief executive of Marks and Spencer's doesn't have to answer to an opposition once a week in Parliament at Prime Minister's question time. He's not faced with an opposition party at board meetings trying to destroy his policies. And he's perfectly well able to adopt initiatives of his own. For example, suppose in one area of the country, Marks and Spencer losing a bit of money, he could lower the prices in the store in that area, or give special discounts or something of that sort. But you can't do that with a benefits system. Or you cost the country millions and millions of pounds, because you create a precedent which is going to be followed, which the opposition will notice and point out in Parliament. And if one particular line of business goes wrong with Marks and Spencer's, they can shut it down. You can't shut down the benefit system or the defence of the country or the other functions that government is doing. It's doing things that no one else can do, probably, and that need to be done. And whether they gain or lose money is not necessarily the central feature. And this also, the fact that you have a system of ministerial responsibility also limits the degree of initiative and creativity that civil servants can adopt, because, as I say, they create precedents which could cost a lot of money. And therefore, they have to keep in the forefront of their mind the fact that in future years, any of the decisions that are made could be questioned in Parliament. They have to keep very detailed records and show that they're keeping to the rules. They're not setting new precedents which have not been authorised and which might cost money. And so the whole mindset is going to be quite different from anything in business. And it's a professional task, being a civil servant, not a business professional task. The skill is public management, which is, in my view, a quite different world from private management. This isn't to say, of course, the civil service shouldn't be efficient, it should, but it's not going to be efficient by adopting the practice of private business. And it's fair to say that governments often misunderstand that, because large corporations tend, for example, to appoint from inside. They don't appoint outsiders, as civil service now does in a mistaken analogy of private business. And they tend to be very suspicious of short-term contracts set for specialists, because they think they're demotivating for people. And I think the analogy that many politicians had, particularly perhaps conservative politicians, was not so much with the world of business as the world of finance, an individualist world of dealing. The civil service isn't like that at all, it can't be. And so I'm afraid I think that we've had many years of misguided approaches to civil service. And the civil service is rather like other institutions where business practice has been adopted, the BBC, the National Health Service, and the universities. And in all those institutions, a main result of adopting those practices has been a fall in morale, a collapse in morale. And these institutions are not suited to the world of private business.
Good, very interesting. So to come back around to where we came in, we were talking about UK has left the European Union. One of the reasons for doing that, or advanced in favour of doing that, was that the Parliament would regain its sovereignty, however you want to define it. In practice, how much freedom of action do you think Parliament and the UK is actually going to have outside of the EU, given some of the terms of the agreement that have been reached? I mean, as a kind of formal sovereignty being gained at the expense of a practical sovereignty?
Well, I think we need to distinguish between two types of sovereignty. The first is parliamentary sovereignty, which is a legal concept and is an absolute. You either have it or you don't. You can't be a qualified parliamentary sovereign, just as you can't be a qualified virgin. You're either a virgin or you're not. Now, another concept often confused with it, which is national sovereignty, which is your room for manoeuvre. That's a political concept. And it's a political debate on how much you should give up. All countries give up something. For example, we give up national sovereignty when we belong to NATO or United Nations or any other organization. But we gave up parliamentary sovereignty, in my view, when we joined the European Union, because that was, unlike those other bodies, a superior system of law, superior legal order. Now, obviously, Brexit restores parliamentary sovereignty in a formal sense. The extent to which it gives us greater freedom of manoeuvre is a political question, and people disagree on that depending on their views on Brexit. In my view, not so much freedom of manoeuvre, because in practice, as I understand the agreement, and it's a complex agreement, and I don't have time to look at it fairly superficially, we have to follow a lot of the rules of the European Union without being represented there. We're in the position of Switzerland, which is tied to the European Union, but not represented there. And leaving the rules could expose us to sanctions by the European Union, which is our largest trading partner. However, it's fair to say, legally, we can do that. Switzerland can say, all right, we are subject to the rules of the EU. It's by our own consent, it's by our own decision that we are in that position. And that's rather better. And some people might say, well, it wasn't so much the rules of the EU that we objected to, but the fact we couldn't decide on them. I think people feel that, for example, about immigration. Survey evidence shows most people quite welcome immigration. Indeed, remarkably, that we are more positively welcoming of immigration in terms of survey evidence than any other member state of the EU. But people want it controlled, managed by us, and not subject to the EU principle of freedom of movement. So it's a complex political question of the extent to which our actual freedom of manoeuvre has increased. But legally, Parliament is, for most practical purposes, I suppose, sovereign.
Yeah, and that's a very interesting point about the length and complexity of the agreement, that in the name of restoring its own sovereignty, Parliament was required to consent to an agreement reached on the 24th of December by the end of the year. How aware could parliamentarians have been of what they were signing up to?
Yes, well, obviously parliamentary scrutiny couldn't be more than superficial on such a complex agreement. But that often happens, it's fair to say, with treaties and executive actions. But most MPs took the view, I think reasonably, that any deal was better than nothing. And in any case, this was the case with Theresa May's deal. It's not really possible for Parliament to unpack a deal. I mean, 650 MPs can't renegotiate. If they unpack the deal, the government would have to go back to the EU. I think the EU would say, well, you know, we're not prepared to do this. This was agreed by us, and we're not prepared to unpack it either. But if they were prepared to unpack it, how can the government negotiate when that's not what it originally agreed? They would say, well, we did favour the original agreement, Parliament hasn't. If Parliament doesn't accept the agreement, as I said at the time of Theresa May's government, what they should do is appoint another government to negotiate an agreement they would favour.
When there was talk of a second referendum last year, if you remember that, seems like a long while ago, there was talk about, let's go back and, I mean, in a way this is counterfactual, but let's go back and negotiate agreement, and then we get a referendum. Presumably, what we'd have been having a referendum on was this agreement that's been reached. So it's quite interesting to ask, should that have been the thing, if for those who agreed to second referendum, should that have been the thing we would have had the second referendum on, and what would that referendum campaign have actually looked like?
Well, I suppose if the agreement was rejected, we'd leave without a deal, because government's view is Brexit is final and not subject to another argument. I suppose there could have been, in theory, it's unlikely in practice, a referendum on whether we should accept the deal or reject it. The trouble with the argument for a second referendum, which I favoured at one point, but I think I was wrong upon reflection, is it wouldn't settle it. If there was a yes vote in the second referendum for staying in, the Brexiteers would say, well, let's have the best of three. And it's the same with the Scottish argument for another referendum. You see, if it resulted in a yes vote, the Unionists would say, let's have a third referendum.
Isn't that the trouble with the first referendum as well?
Well, no, it gave a decision, one way or the other. It gave a decision. Resolved, the issue's resolved. We're out. Resolved for the first referendum, resolved it. The 1975 referendum resolved it for just over 40 years. And this one, 40 years, reasonable. Perhaps in 40 years' time, people might say, well, why don't we join? Rejoin. We don't know what the world would be like then, but it's resolved it for the time being. As the 75 one did, it legitimised Brexit. I didn't favour it, but if people don't want to be in the European Union, we shouldn't be in it. Democracy.
Well, we can come back and have another discussion about that in 40 years' time and see how things are going along then. A final question: how is a written constitution any closer now than it has been previously? Is it further away? Does it look like a plausible outcome? I know it's something we've both argued in favour of in different ways at times.
Well, it was you who first told me that Brexit might be a constitutional moment, which I'm grateful to you for that. It's enabled me to write various articles and books on that theme. And it's worth remembering when people ask whether we should have one. In a way, that's not the question to ask. The question is, what so abnormal about Britain. We don't, because every democracy apart from New Zealand and Israel do have written constitutions. Israel's trying to develop one very slowly. New Zealand's a country of about 5 million people, broadly homogenous, certainly compared to Britain, not as multicultural or multi-denominational as Britain, about half the size of Greater London. What is there about Britain? Well, the obvious answer is the principle of parliamentary sovereignty. Now, we do live, as I've said, in an unprotected system, and I think that is dangerous. We were in a protected system in the European Union, and I think it is time we began to look at that. I think the most urgent thing is to have a charter on the relationships between Westminster and the devolved bodies, and Westminster and the various regional mayors that we've got. And COVID has, I think, really emphasised the importance of that. We've devolved in an ad hoc and unplanned way, and we need to decide for ourselves what Westminster needs to keep to preserve not only the constitutional and political union, but also a social and economic union. Would we be happy, for example, if pension rates differed in different parts of the country? If one part of the country decided to charge for a visit to the doctor and others didn't? I mean, what is basic to our country? We need to have that debate, I think. I think that's urgent, and the Constitution might follow on from that. I think Gordon Brown wanted to introduce one when he was in power, and had he been returned in 2010, he would have hoped to have one for the 800th anniversary of Magna Carta in 2015. But as we know, he wasn't in power. It may be a future Labour government, especially if the Liberals have any role to play. A future Labour government would be sympathetic to that. The Conservatives aren't. There's no question of that. So at the moment, it's not on the agenda, but it must come back, I think.
Good. Well, it's something we can hopefully continue to talk about. That's been great. Thank you very much, Vernon. As ever, fascinating interview. And have you got any books you want to promote or anything you'd like to?
Well, how kind of you to ask. As you know, I did a book on the very topic we've just been mentioning.
Yeah.
In 2019, called Beyond Brexit, Towards the British Constitution, which perhaps is a bit hopeful. But at the end of last year, I published another book on Brexit based on my Yale lectures, Stimson lectures at Yale, called Britain and Europe in a Troubled World, which deals with the question of how we came to vote for Brexit in the first place and the effects of that on the international position of Britain and indeed on the international position of the EU. And I end up with a chapter which has annoyed a lot of the Remainers. I was a Remainer myself, but a lot of the Remainers think the EU is a kind of panacea and absolutely wonderful. And I said it should be a wake-up call, not just for Britain, but for the EU as well, which needs to reform itself if it's going to be more friendly to the people of Europe. So I rather hope people in Britain and in the EU will read that book. It's called Britain and Europe in a Troubled World and published by Yale. And thank you for giving me the chance to make that blurb advertisement for the book.
Not at all. When I've read it, I can definitely recommend it. And it's presumably available on Amazon and through the usual outlets and that kind of thing.
Yes, well, if it wasn't for COVID, I would sign people's copies at no extra charge. And it was always said the very rare copies of Edward Heath's books were those that actually weren't signed by him. He signed so many. With COVID, one can't really sign books, but I hope people buy it. I think you can get it fairly cheap on Amazon. So thank you again for allowing me to advertise.
No, thank you. Not at all. Thank you. Professor Vernon Bogdanor, thank you very much.